So are you ready to proceed?
Ready?
Yes.
All right, we will begin. This is the time set for oral argument in Curtis versus Banner, our case number CV190621. Counsel, each side does have 20 minutes for oral argument today. In a more normal time, you would have a podium clock that you would look at and that appellee could look at to, or appellant, pardon me, could look at to reserve time for rebuttal. These are not those times. I am keeping sort of a more informal stopwatch time as we go along, but if appellant does wish to reserve a portion of your time, you'll need to keep track of that along the way as well. We have conferenced the case. We're familiar with the record. We would encourage you to, in your briefs, of course, and would encourage you to keep that in mind as you do present your argument today. Our proceedings are being recorded, so please keep that in mind and also let us know your name and the party that you represent when you first take the virtual podium. How about that? With that, Mr. Enos, you may proceed.
I would like to reserve somewhere between 3 and 5 minutes.
And sir, I'm going to need you to speak a fair bit louder because I want to hear every word. And I don't know if my colleagues are having trouble hearing, but I do want to make sure we can hear everything you say.
Is this better?
A little bit.
Well, I may have to approach the podium.
There, that's better. And we'll be quiet on our end too. How about that?
I will attempt to enunciate clearly. My name is Christopher Enos. I represent the appellant Lisa Curtis in this medical malpractice action. And as the court's noted, it's read all the briefs. I'm not going to go on to it, hopefully, but I do wish to emphasize that this is a case for summary judgment. That means there has to be evidence presented to rebut the idea that there are no findings to be made by a jury. We, I believe, have as the primary issue in this case the standard of care, whether or not it was established. We have proposed 2 ways that we have established that sufficient facts for a jury to be able to make a finding as to what the standard of care was and whether or not it was violated. First is presented by the defendant itself, and that is the critical results reporting procedure. This was a document that was disclosed on December 3rd after the motion for summary judgment was filed and served. And that we learned and then were able to have a deposition of Dr. Vance. The deposition of Dr. Vance qualified the document, and it elucidated on it as well as a log that he was presented. And in that log, we learned that the identification of a nurse was made as the person who received the notification from a lab with regard to a critical blood test. So why is that the establishment of a standard of care? Well, because the defendant has said specifically what an employee, in this case a nurse, who is employed by the defendant should do when it receives a critical blood test. There wasn't any guesswork involved. It basically said, this is what you do it within an hour, you make a call, you call a doctor, you then get instructions from the doctors to what to do, including calling the patient for further care, as would be prescribed by the doctor under the circumstances that are then presented. Well, that simply then gives us the roadmap or the measuring stick as to by which we can see whether or not someone fulfilled the duties that are required in the duty of care to that might be established as the standard of care. So a jury would not be sitting there alone wondering what a nurse should do. They would have specific instructions promoted by the defendant itself saying, this is what a nurse should do, this is when we should do it. The next question would be, well,
counsel, let me ask you before you get to that next question, a hypothetical. You're relying on the internal procedure for the defendant as setting forth the standard of care for effectively for a nurse to obviate the need for an expert. What if the protocol instead, and this is a hypothetical, simply said when blood or when test results are returned, the nurse can do whatever he or she wants? Under your view, that would still set the standard of care, right?
No, because at that point you're leaving it open to nurse's judgment. You can do whatever you want. It'd be like saying to my kid, you can decide whether or not you want to do your homework. In this case, the defendant said, you got to do your homework. You got to call the
I understand. I'm asking you a hypothetical. So I'm not seeking to confuse this protocol versus that hypothetical. But let me ask you another hypothetical. What if instead the protocol simply said you removes all the judgment that you just pointed to and says the nurse doesn't need to do anything?
Well, that's a good question, because at that point there's a complete dereliction of duty, and you probably have to have somebody come in and say that there was a dereliction of duty. And you say it doesn't say anything, basically then there's no protocol. Then you would have to have an expert come in and say what the duty was. In this case, you have a protocol.
Well, and what my point is, and you've identified it, is why does the law, or what's the best case in Arizona to assume that the law presumes that internal protocols either meet or exceed the standards? Because that's really what your argument's based on, right?
Well, the law says the defendant gets to say what it's going to do in its own hospital. And in this case, the defendant has spoken and it said, this is what you as a nurse should do when you get the protocol.
I understand that, but in my hypothetical, that same statement is true.
That is true, but the question is not whether or not it's conclusive. The question is whether or not it's evidence that may be used by the jury in determining the standard of care. The jury could come back and say, you know what, that protocol that they got, that isn't enough, or the protocol is enough. In that case, they're determining what the standard of care is. So,
and if a protocol, an internal protocol, whether it meets or doesn't meet the standard of care, is sufficient to take a claim like this to the jury, anytime a hospital has any sort of written internal policy, you don't need an expert, right?
No, because you just said any type of internal policy. We have a specific policy relating to a specific item, namely a critical blood test result. And the specifics of this critical results reporting procedure take it out of the ordinary. It's not just saying you really ought to do your best and that's all that really matters. It doesn't say that. This protocol is explicit, goes on for pages in step-by-step fashion, describing exactly what should be done. And that takes it out of the ordinary and allows the jury to say, we're going to consider this evidence. We're going to consider that this prescribed what the defendant's employee should have done with that critical result.
Counsel, let me ask you, what if this internal policy was, in law, we have sort of legal writing, which is sometimes incomprehensible. And I suspect we have the same in medicine. What if this was a dense sort of medical sort of anchored document that could, that might have set or explained what's aspirational, what the hospital aspires to do, but is written in words that the ordinary juror couldn't understand? Would it still be your I'm sorry, would it still be your argument that no expert is required? I mean, isn't that?
I'm sorry. My argument, Your Honor, is that the jury is entitled to consider it. Under your positing of this horrible sophomoric enterprise of a protocol, the jury could dismiss it and say, we don't find that that's the standard of care. We don't think that's the standard. We think that's a mush. And we, no other evidence being provided. Quite frankly, we're going to dismiss the case. We're going to find for the defendant. They could do that.
So let's not characterize it as sophomoric, because I'm actually trying to go in the opposite direction. I'm saying that these are absolutely hardcore physicians and scientists, but they speak as they speak to one another in this document. And so it refers to a disorder that might be a headache with some word that has 72 letters, okay? And that is perfectly comprehensible to any other physician, not so much the ordinary juror. Is it still your position in that situation that no expert would be required?
If you go in without an expert under that hypothetical, you're operating at your peril, because you're now looking to the jury to interpret a document that say whether or not this is the standard of care. And I respectfully submit that's not the case here. We have a relatively simple document that gives virtually step-by-step instructions what to do in common English. And it says, when receiving these results, you are to call a physician. You're to call a physician within 60 minutes or less. And whatever the physician says to do, you're then to do it. That is not that difficult, Your Honor. And I respectfully submit that no other expert testimony would be needed to interpret that there is no such scientific language contained in this protocol. The protocol is simple and easy for anybody to understand. I even understood it.
Counsel, let me jump in here and just ask a follow-up question to something Judge Thuma had asked. What's the best case that supports your argument that a hospital protocol alone, by itself, is enough to go to a jury to establish standard of care?
Well, obviously, the Peacock case would be the case that Peacock case would be the one that I'm relying upon, and I've gone on about it in the reply brief extensively.
So let me ask you a question about that, if I could. Doesn't Peacock distinguish that it's not just the protocol, it's the protocol together with the reasonable inferences that, and I'll quote from it, the protocol together with reasonable inferences that can be drawn from the act of placing a reportedly suicidal patient in a fourth floor room with an unsecured window, those two together was enough to go to a jury to decide if that was the appropriate standard of care. Something that seems more common sense.
Well,
and so the question is what's so common sense about the timing required to report blood culture test results that wouldn't require some sort of medical knowledge for jurors to understand? In other words, how is this protocol and the facts of this case, it seems maybe it's a little distinguishable from Peacock. Help me understand how it's not.
All right. So basically, I was actually going to go into that when Judge Thuma said, let's ask some questions. And that relates to how a defendant did or did not meet the measure of the standard of care. If the standard of care is established by the protocols, how difficult is it to understand what wasn't done? In the Peacock case, it was easy to understand that putting a person next to an open window didn't conform to the protocols. In this case, it's easy to understand that failing to make any phone call whatsoever was failing to meet the protocols. And together, the inference was that there was a violation of the standard of care. And that could be drawn by the jury. First, the jury has to determine what the standard is, and we submit that can be done with the protocols. And secondly, they then have to look at the actions and say, well, it's pretty easy to understand that not making any phone call whatsoever is a violation of those standards. In other words, this didn't have anything to do with mental health. This didn't have anything to do with leaving the window open per se. It's had to do with the court in Peacock saying the defendant had spoken as to what should be done. You should lock the windows. You should do whatever was prescribed in those protocols. And then they said, well, the fair inference can be drawn that there was a violation by the fact that it was left open and they did not conform to the protocols. The fair inference could be drawn that there was a violation of the standard of care.
I'm sorry. Is this fair to say that Peacock is a little bit of an outlier in the sense that Bell and most other cases seem to make clear that when it comes to a medical negligence, a medical malpractice case, you need an expert to establish standard of care. Is Peacock a little bit of an outlier?
No, I think it's only an outlier because you don't have that many protocols involved in these cases. In Bell, there was a protocol, but that was a case that went to the jury, and then they said, well, we wanted a special instruction on the protocols. And the court said, no, you went to the jury. The protocols were included. It's up to the jury to determine what the standard of care was, and they could apply the protocols or not. So that's what Bell said. And you simply don't have that many cases where the defendant comes out, gives specific directions, and then has those directions violated by its employees. So no wonder you don't have too many cases dealing with this type of thing. So it's an outlier, if only because of the rarity of protocol, specific written protocol, a mandate by a hospital being violated by its own employees.
But isn't doesn't? Oh, I'm sorry. Can you hear me?
Yes.
Let's try to think of what the parallel would be to Peacock here. What if somebody's a blood test came back or that they had HIV and no call was ever made, or a test came back that someone had cancer and no call was ever made? The ordinary juror, just by living, might be able to understand that falls below the standard of care. Would you agree with me that would be sort of the parallel of Peacock, the obviousness of both the disorder and the lack of a call, but that everything maybe in between? Like, I'm no expert on blood cultures or staph infections, and I think I would benefit from a medical expert. How would you answer that? Isn't that what Peacock is saying, that don't leave the window open with someone who is suicidal? Yeah, that's something you don't do. You never make the call, you're HIV positive? Yeah, that's something you don't do, and I might not need an expert. Here, we have the word critical, modifying test results. We have a disorder that I don't think at least I'm not, and maybe I'm just not. My dad was a physician, and I stayed far away. But I would certainly benefit from that. Is that what Peacock means? Sort of that obvious point?
No. What Peacock means is that there was a protocol involved, and that the defendant's employees failed. In this case, Your Honor is basically saying, well, what do we really know about critical? Was that really the critical result? And we have here, though, additional evidence that can be considered by the jury, namely the testimony of Dr. Vance, who said this is a critical result. It was subject to the protocols. It wasn't followed. Those are facts. Those are items now in evidence that a jury can say, oh, well, whereas, whatever their family might be, they didn't have a doctor in there either, but they can still say, well, we have Dr. Vance telling us this is a critical result. It would have been very important to me. I didn't have the right diagnosis. If I had been told, I would have done things differently. Those are facts from a fact witness. And when you combine that with the protocols and the fact that there was no call made, that's the obvious violation. The fact that no call was made. So whereas in Your Honor's sample question or example question, there was no call made relative to HIV, it only goes to whether or not HIV is recognizable as something subject to being reported. In this case, we have Dr. Vance telling us that, and he is a qualified expert to determine items with regard to blood tests, but on top of that, he's a fact witness. The facts then being submitted to the jury then can conclude that there was a standard of care, that is to submit critical results to a doctor within 60 minutes, and that take in Dr. Vance's testimony that this was a critical result. And by the way, there was an alert on the the microbiology log, and then determine, no phone call was made. We believe that this was a critical result. We believe that the standard of care was that it should have been reported, and we can see that no report was even attempted to be made.
Let me ask a question real quick here. I missed it if it's in the record. Is there anywhere in the record that an expert witness, either plaintiffs or defendants, opine that the critical results reporting procedure is equivalent to the standard of care? Has an expert witness on either side made that connection?
Well, we had Dr. Vance testify that this was the policy of the hospital that applied to nurses, and this is what should be done in those circumstances. We believe that that's enough for the jury so they can make the determination whether or not that was the standard of care. So with the direct answer is, outside of some expert coming in with a beard and a briefcase from Vienna, you don't have anybody saying here, oh yeah, this is the standard, all right. No, what you have is the hospital itself saying this is what should have been done, and a jury can use that as evidence to determine the standard.
Thank you, Mr. Enos. For planning purposes, I have you with about 2 minutes for rebuttal. So time goes fast, but Mr. Egbert.
Thank you, Your Honor. My name is John Egbert. I represent the defendant, Banner Health. My friend on the other side indicated that he was going to talk about 2 ways that he survives the summary judgment. I think he only talked about 1. So I'm just going to take a very brief moment and do some cleanup to talk about it. Unless the court wants me to focus just on the protocols, I'm happy to do that as well. But there is an argument that they made in their briefing related to a motion for additional discovery under 56D. We've demonstrated, we believe, that there are at least 2 reasons why the court did not abuse its discretion in denying that motion. One was that it wouldn't have made any difference because the issue was whether or not they needed a nurse expert. They didn't have one. And even if it would have made a difference, the judge was very careful in exploring with counsel what discovery was done, why couldn't you have done discovery to get this information, and very clearly made the determination that there had not been a diligent effort to obtain it. So we think clearly no abuse of discretion on that aspect. The next cleanup item is they argued that they did present, although untimely, a nurse expert, 5 months after the expert disclosure deadline, and clearly no abuse of discretion in that situation to not allow them to use an untimely disclosed expert. So then we're back then to what's left. And the 2 arguments that they made in their briefing was, number 1, this is a grossly apparent standard of care situation, as the Supreme Court has described that in the Razor decision, and many other cases, by the way. This is a standard that has long existed, that if it isn't grossly apparent, you have to have an expert. And our state legislature has very carefully and in detail set forth a number of statutes, which has evolved over time in describing what expert is allowed to do that testifying. And clearly, in this situation, I don't think there's any dispute. We've got to have a nurse expert testifying about the standard of care and deviations from that standard. The other argument, and I'll come back to that in just a moment, in terms of grossly apparent. In fact, let me just clean that up too, because I think this is not a case that even comes close to qualifying for grossly apparent.
Well, let's explore that, counsel. So would you concede that no medical expert would be required if a surgeon leaves a scalpel inside the body of a patient?
Potentially, yes.
Yes, what?
Yes, that a jury could determine that that's the standard of care, is not to leave a scalpel inside someone's body.
So how is this case different?
This case is different because at issue is when a nurse receives report of a blood test, what, if anything, is that nurse supposed to do? Now, you indicated a few minutes ago, Your Honor, that, notwithstanding having a father in the medical profession, not sure, I'm not sure, I don't think any reasonable juror would know, is this something a nurse is supposed to do something with? Or if so, how quickly? How long of a delay is too much? Lay people just don't know that. You have to have a expert, and under our statutes, it has to be a nurse expert, come in and say that the standard of care when a nurse in Nurse Birdie's situation receives that report, he or she needs to do X. And unless you've got that, you haven't satisfied what you need in order to avoid summary judgment. And so this isn't grossly apparent at multiple levels. Is the nurse supposed to do anything? And if so, what is it? That isn't apparent. You could poll 20 people and get 20 different answers on that. So I think that's an easy one, Your Honor, with all due respect. The other argument that they make then is what counsel spent most of his time talking about a few minutes ago.
Mr. Egbert, I think Judge Williams may have had a question. I'm sorry.
If you're going to go a different direction, let me ask a follow-up question on this. So when we review summary judgment, we're supposed to view in a light most favorable to the party opposing summary judgment. And what do we do with language like this from Peacock? Where Peacock, this court acknowledged that the existence of a hospital policy is not necessarily always going to equate to standard of care, but the existence, this is from Peacock, the existence of a hospital protocol is nevertheless some evidence of the standard of care. And then this court went on to explain that a jury could conclude that the protocol is the standard of care and that the failure to follow the standard of care was negligent. So is a hospital protocol some evidence of the standard of care?
There's two different issues, and I think the court in the Bell decision focused on the distinction. You have to have expert opinion in order to get to the jury in the first place. If you have a situation where you have dueling experts, the plaintiff's expert says, here's the standard of care, defense expert says, no, that's not the standard of care, then can there be evidence based on what was the practice of those respective experts or the parties themselves? Can that be admissible for purposes then of helping the jury decide between those two competing expert testimonies? Absolutely. So it can be evidence in that sense, Your Honor, but it doesn't equate by itself. And again, in Peacock, it wasn't a by itself situation. In fact, this court said in the Potter case, described Peacock as holding that was a situation where the Court of Appeals accepted the plaintiff's argument that the standard of care was grossly apparent, and then moved on. And in fact, says it took a step beyond that and started talking about, okay, these protocols. But my position would be, I think the way you kind of make sense of Bell, Peacock, and Potter all together is that once you've satisfied the requirement of having that expert testimony, or determined that it's grossly apparent and you don't even need expert testimony at all, then you're in the situation of like the Smethers case cited in my papers, that it's now evidence. Now that we've passed that threshold, that we now have evidence, we need evidence to help the jury determine, so who's right? What is the standard of care of these competing notions? And if for example, in the Smethers case, where the court said, no, the trial court got it wrong in not allowing evidence about what the expert actually does in his practice. He's testified that the standard is down here, but yet he does something up here. So that could be relevant in testing the credibility of these competing experts. That's a different issue, though, than what we're really talking about. We're talking about, can a policy, a protocol in and of itself substitute for expert testimony when it's not grossly apparent? And the answer to that is no. If the answer isn't no, we've got very bad public policy, because then we've got no hospital in fact, no medical professional ever would aspire to certain policies and try to tell its people, hey, let's lift it up to this level. Let's not strive for, maybe the standard of care is achieving a 50% rate, 51%. More often than not, we're not going to kill somebody. But if the hospital then strives for a 75% rate of success, then that's just going to be held against them. Who's going to ever do that? That's bad public policy. What's missing here, and what the case law says has to exist, is there has to be some expert that links that policy or that protocol to the standard of care. All you need is to have plaintiff's expert say that policy that they themselves enacted, put into place, that is the standard of care. With that, they've passed the threshold, and then the litigants can fight and try to convince the jury as to which, whether that's true or not. But unless you have that link of that standalone policy to somehow some appropriate expert saying that equals the standard of care, they haven't met the threshold, and summary judgment is very appropriate under those circumstances.
Thank you, Mr. Egbert. Just one comment. You referenced Potter, and Potter seems to acknowledge that there's a split in authority in Arizona, Bell, Peacock. But from what I hear you saying, you disagree there's not a split.
Yeah, so I struggle with this, Your Honor, to be candid. In Potter, the court seems to suggest they are at odds. I don't think that's necessarily true. So I would say you, a few minutes ago, used the description of outlier. I would say it's either an outlier, or that's how I would try to make them compatible, so that it's not an outlier. I would say Peacock really is a situation where, in the first instance, they found that no expert was needed because it was grossly apparent. And once you do that, then you bring in this evidence. This evidence can be admissible in the normal course, like happens frequently when either the defendant or the defendant's expert themselves simply say, yeah, the standard of care is XYZ. And the plaintiff says, yeah, we'll live with that. And then you can bring in additional evidence to support that. So, but that's not our case. But that could be one way you make sense of Bell and Peacock together and Potter.
Any other questions for Mr. Egbert? Mr. Egbert, anything you wish to add?
I think that covers it, Your Honor.
Very well. Mr. Enos, I did 120 good seconds. Time does go fast here, but please proceed.
All right, Judge, thank you. First of all, the situation that Mr. Egbert just described is specifically anticipated in the Peacock decision. After the introduction of the protocols, the defendant is then free to introduce whatever other evidence it wants to say they don't apply. That can be expert testimony, it could be anything. And the plaintiff could provide additional evidence as well. That does not take out of the jury's consideration the initial protocols as evidence of the standard of care from which the jury could deduce what that standard was, and then going by the clear failure to comply with that standard, deem it was obvious and as such negligence. I never did get to the expert opinion. We supplied an expert opinion, and we supplied it pretty timely, Judge, given the fact that this motion was filed before the close of discovery. We had no indication that there was going to be a nurse as an expert until the defendant gave us that indication in October 1st and 2nd. And after that, we then took it upon ourselves to obtain additional discovery from the defendant, which it provided after the motion. And at that time, we then went forward and got the deposition from Dr. Vance. Using the deposition, we, within 2 weeks, got a opinion from Nurse Anderson. The opinion from Nurse Anderson, everybody is going to submit, is, I'm sure, sufficient to qualify as an expert opinion on this case and would warrant dismissal of the motion. So We feel that on balance, the court should consider that. We also would, I was going to mention the Simon versus Safeway case, which really talks about when a 56D motion should be granted. And that is somewhat applicable to this case, although it's not medical malpractice, because it said, well, where you've got a situation where you have a statement by the defendant of its policy, which is similar to the protocol here, and the disclosure of that, then the plaintiff should be able to expound upon that with witnesses. So we believe that the 56D motion being partially granted gave us the relief we needed. We used that relief to then go forth and get the testimony from Dr. Vance, which we then used in conjunction with the microbiology logs and the protocols to obtain an expert opinion from a qualified nurse. And we believe that it's well within it should have been the court's discretion to permit it under those circumstances. And this court is not prevented from reviewing those circumstances.
Counsel, thank you. We appreciate your argument today. We appreciate your briefing. We will take the matter under advisement and we'll issue a written ruling in due course. Thank you both. Court's adjourned.
Thank you.